failed to hold President Jacob Zuma to account. The court made the finding while ruling on whether Parliament should initiate impeachment proceedings against the president. The Constitutional Court, though, found that the case is a textbook case of judicial overreach and that it would be intruding into Parliament's domain. It ordered for President Zuma to pay the case's costs.
1. This court has exclusive jurisdiction to hear the application. 2. The failure by the National Assembly to make rules regulating removal of a president in terms of Section 89, Sub 1 of the Constitution constitutes a violation of this section and is invalid. 3. The National Assembly must comply with Section 237 of the Constitution and make rules referred to in paragraph 2 without delay. 4. The failure by the National Assembly to determine whether the President has breached Section 89 Sub 1A or B of the Constitution is inconsistent with this section and Section 42(3) of the Constitution. 5. The National Assembly must comply with Section 237 of the Constitution and fulfill the obligation referred to in paragraph 4 without delay. 6. The National Assembly and the President must pay costs of the application jointly and severally, including costs of two counsel where applicable.
Our reporter Aldrin Sampier has been following the story. Let's cross to him now. Good afternoon, Aldrin. Give us a simple explanation of the judgment that was handed down.
An extraordinary judgment that has been handed down, and also taking into consideration that there are two dissenting judgments as well that have been written in this court case. This judgment that has been handed down essentially means that the National Assembly has failed in its duty to hold the president accountable after this court had already found last year in the Nkandla judgment that the president failed to uphold, defend and protect the Constitution. That's what it means. It also means that there is now a declaratory order in terms of the failure to hold the president to account. But it goes a step further in terms of interpreting Section 89 of the Constitution, which deals with the interpretation which deals with the impeachment of the president. The Section 89 of the Constitution states that there must be grounds, and the argument that has been established is that there must be an establishment of whether the president has violated the Constitution and the extent thereof of the Constitution being violated. And the court has found that Parliament as it stands does not have rules which deal with the impeachment of the president, because as they found that there should be at least a preliminary inquiry. But the rules of Parliament don't have that as it stands at this moment, and Parliament has now been ordered to, without delay, quote unquote, make sure that it include these rules, the rules that would complement Section 89 of the Constitution on how do you deal with the impeachment of the president. And just looking through the judgment also indicates that this must be done without delay, and because it's such a serious issue involving the highest office in the land, this particular issue must take priority. And the big question is, take priority how? In how many days must Parliament ensure that it has these rules that deal with the impeachment, that deals with the proceedings of an impeachment? It will be something quite interesting that we'll have to watch very, very closely. On the other hand, the court has also found that an ad hoc committee, a multi-party ad hoc committee, similarly to the one that we saw back in 2014, looking into the Nkandla report of the Public Protector, is not the right system to use, because the argument that has been used is that the majority party could use their majority to frustrate the other political parties, and essentially the president will not be held to account. And this is another interesting one, because the court doesn't say how exactly this preliminary inquiry into the president's conduct must be held, what mechanism must be employed. It has left it up to the National Assembly to determine exactly which mechanism must be established. But Nzinga, just to add quickly, when the EFF wrote to the Speaker of Parliament last year after the Constitutional Court judgment, they said that the inquiry that must be established must be an inquiry led by 3 retired judges, and there must be a prosecutor, meaning that there must be an evidence leader. One then wonders whether this will also then be put on the table, that this is a potential way on which Parliament can interpret this Constitutional Court judgment and ensuring that it adheres to Section 89 of the Constitution as well as Section 235.
Aldrin, what did Justice Jafta say about the separation of powers?
This is a very important one because what you see in this judgment is that the justices really tried very, very hard to ensure that they don't encroach on the separation of powers, that they don't encroach on the powers of the legislature in terms of holding the president accountable. And that's the reason why, for instance, they are not saying which mechanism should be established or should be used to ensure that there is a predetermination with regards to the president's conduct. But interestingly, and I just want to read this portion of a judgment that was the dissenting judgment from Justice Mogoeng. You may have noted while Justice Chris Jafta, who was handing down the majority judgment, when he was about to go to Mogoeng's judgment, he then leaned into Mogoeng, and Mogoeng had passed him on a note, and this was with regards to the dissenting judgment that Mogoeng has written, that he doesn't agree with the judgment that has been taken, or the decision of the majority. And just looking into that full judgment of Justice Mogoeng, the dissenting judgment, just take a listen to the words that he uses here as well. He says, and this is paragraph 254, he says, this time around we are not only specific about the size, the representation procedure, the provisions for the entirety of the process, avoiding abuse of the majority representation, institutional predetermination of grounds before debating and voting on impeachment, but we are even ordering the National Assembly to table an impeachment motion that no party ever tried to table for the debate within a specified period. Then, in my view, quote unquote, he says, it is unprecedented, unconstitutional, and an unconstitutional encroachment into the operational space of Parliament by judges. Paragraph 3 and 5 of the order highlight the quote unquote absurdity of that decision. Quite strong words that you have here from Justice Mogoeng in his dissenting judgment, and that's the reason why the EFF had such strong words for him, saying that this is and this amounts to an abuse of power.
Aldrin, we know that we can't tell what's going to happen, but how much of a difference do people you've spoken to, or do you think that it will make on a possible impeachment now that President Zuma is not president of the ANC?
Well, we have to speak about impeachment proceedings because the impeachment is not on the table as it stands. And the EFF is saying that over the next 30 days, they will ensure that Parliament adheres to this court ruling and implements the court orders as well. But then, of course, there's the issue around the State of the Nation address. What happens now? Do you do this before the State of the Nation address, or do you do it after the State of the Nation address, which is in February, the second month of the year? And also take into consideration that the majority judgment that has been handed down has also indicated that these rules must be implemented, or the rules must be adopted without a delay, and that this issue must take priority because it involves the highest office in the land. It's certainly something that we need to watch very closely.
Aldrin Sampear coming to us live there from outside the Constitutional Court. We're going to stay with that story.